All right. And just We the People News. Okay. Not attorney, not giving legal advice. Educational purposes only. All right. Never look straight forward. Just always look around you. Be able to protect yourself by any means necessary. Arm yourself with knowledge. All right. Now we're back to the 10th Amendment Center because they got great stuff. In my last two videos, I kind of showed the off and ons of merchant, the bankruptcy, a little bit flavor. Uh, but what was the original intent? Okay, if it's contradicting the original intent of the founding fathers, then it cannot be constitutional, right? And again, tyranny, right? Um, so check out his channel and watch his whole video because I just want to kind of give a basic idea of the where the tyranny begins and how it led into the last two videos, right? The bankruptcy and theft of your property and how it's been mortgaged out and all that kind of stuff when they didn't have no authority to do so. All right, let's go.
To it. In the first Congress, Representative James Madison, we know, proposed a bunch of amendments that eventually turned out to be the Bill of Rights. But he also included in his amendment proposals in June of 1789 a kind of a 1-2 punch. He wanted a brand new Article 7 in the body of the Constitution that would have expressly included separation of powers and a precursor to the 10th Amendment. And here's what he proposed. Eighthly, that immediately after the Article 6th be inserted as Article 7th, the clauses following to wit, the powers delegated by this Constitution are appropriated to the departments to which they are respectively distributed, so that the legislative department shall never exercise the powers vested in the executive or judicial, nor the executive exercise the powers vested in the legislative or judicial, nor the judicial exercise the powers vested in the legislative or executive departments. And the next clause.
And there's where we realize the problem, right? So during the 1946 Administrative Act, Congress actually gave more authority to the president that's not dedicated to him. They put administrative in there to be able to wash their hands and say, here you go. You only get to be voted in twice. So us congressmen, we can spend a lifetime here, and we don't want to be voted out. So we're going to hand it to the president so he takes full responsibility. And meanwhile, the senators and Congress will just sit there and back and say, ha, 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 we screwed you, president, and the people.
The powers not delegated by this Constitution, nor prohibited by it to the states, are reserved to the states respectively. Now, if we understand the context of what Representative James Madison, the so-called father of the Constitution, was doing here, he understood that the Constitution was very close to losing the ratification debates. It almost lost, and it was only turned around once John Hancock and Samuel Adams up in Massachusetts agreed to a deal where they were going to approve. It was going to fail in Massachusetts, which means it was probably going to fail in New York State and in Virginia, and it was done. And so Hancock and Adams made a deal that said, okay, we will make basically a gentleman's deal, and we will agree to do this as long as you guarantee to us that you're going to give us some amendments later on, because we're okay with making changes. We just don't want it to be poorly defined. And some of the concerns they had issues with, the first thing in Massachusetts, for example, was
and that's the key word. It's not supposed to be poorly defined. It's supposed to be clear and understood by the average people, right? And then, and like on the administrative, everything is designed to be complicated for everybody. You got 20 fucking statutes that goes to a speeding ticket. in order to fight this, you must go through all 20 statutes to try to beat your case. And I'm just using that as a figure of speech, technically, like speeding ticket. Just a speeding ticket by itself in Texas. They only use 2 when there's 4. So the judicial branch, and I say that loosely, the administrative branch, the magistrate, is ignoring 2 of the statutes on purpose, on design, and they have unclean hands, they're acting in dishonor, and they need to be disposed of. And it goes all the way up to appellate courts here in Texas. But the appellate courts can be judicial or administrative. And so they're going to still use administrative and back up the lower courts. Again, violating your due process of canceling out 2 statutes that can help you.
Hancock and Adams, working with some people on the other side, they proposed a recommended amendment that became the 10th Amendment. But separation of powers was a big issue amongst the other states as well, who were proposing recommended amendments. So Madison didn't even really want to have a Bill of Rights. He argued against it along with all the other Federalists, but he understood kind of the political need for this. And I think part of what was going on here, and maybe we'll see a little bit more in just a moment, was that Madison was proposing stuff to make sure that the opponents, here it is, in the first few months after the first Congress started meeting in 1789, I think he was trying to kind of diffuse tensions a little bit, even though he wasn't thinking that these were needed, because he, like everyone else on the Federalist side, didn't think the 10th Amendment was needed because the system was set up so that all powers not delegated were reserved. But the Anti-Federalists said, well, we had it spelled out like that in the Articles of Confederation. The fact that you're taking it out of there makes us very concerned. So Madison understood that and included that as a recommended amendment. And same with the notion of separation of powers. But in those debates, after Madison proposed this, we get here from Elon Werman in his non-delegation at the founding paper. He points out, he went through a little bit of history on this, that Representative Roger Sherman objected to Madison's proposal, especially on separation of powers. He conceived the amendment, quote, to be altogether unnecessary, inasmuch as the Constitution assigned the business of each branch of the government to a separate department. So people like Sherman, one of the leading founders, of course, real old school guy, he's like, what's the point of this? This is totally unnecessary because we've already spelled out what each department can do. And nothing in there says that each department can kind of pass the buck. There's nothing in the Constitution that allows them to transfer powers. And there's nothing in there that says that they could do anything remotely like that. And Madison, Werman points out, Madison agreed with Roger Sherman. It actually is unnecessary. But, and if you think of the context of what Madison...
And there's nothing in the Constitution says the Supreme Court is the law of the land. It's opinion. And if it's contradictory to the Constitution and your freedom, your rights, then it's null and void. Right? It cannot be. And we, the people, have not only an obligation, but a duty to ignore it, as well as all the states can do that as well. Right? But we're not doing it. So stupid Supreme Court rulings, Terry versus Ohio, right? Pennsylvania versus Mims, and a few other destructive court opinions that is torn into our rights without a warrant.
Doing and proposing amendments there in 1789, he supposed the people would be gratified with the amendment, as it was admitted that the powers ought to be separate and distinct. It might also tend to an explanation of some doubts that might arise respecting the construction of the Constitution. So he was basically with this proposed amendment, this new Article 7, the 10th Amendment and separation of powers, this was really a tip of the hat to his opponents. I think it's very honorable that that's what he was trying to do. He didn't even think it was needed, but he was doing it to lessen the fear and the concern of the opponents of the Constitution right out of the gate. Now, you might be wondering, with all this that we're talking about, what the hell happened? How did we get from there to where we are today? And you probably will not be surprised that it has its roots really not fully rooted in the New Deal, but that's where things really exploded. Here from 2020, Mike Rappaport at the Originalism Center blog, he said it was 85 years ago, so now 90 years ago, that the Supreme Court used the non-delegation doctrine to strike down important delegations of legislative power in a few cases during the New Deal. And that was the end of it. But the doctrine, he wrote, fell prey to the New Deal judicial revolution. With the appointment of New Deal justices, the Supreme Court started to apply the doctrine extremely leniently to allow enormous delegations of policy-making discretion to the executive. And in essence, the executive is where almost all the laws are written these days, but it's now considered just policy-making or regulation writing. And it has nothing to do with Congress. Congress just writes a bunch of open-ended stuff, and then the executive branch just puts it all together however they want it. And he said, since the New Deal, and this is really important, since the New Deal, no delegations were viewed by the Supreme Court, and there have been many. None have been struck down as unconstitutional. So here we are 90 years, and not a single Supreme Court opinion has struck down a single act of Congress unconstitutionally delegating its legislative power to the executive branch. Not once. I reserve my right to be wrong on this because it's been 5 years since Mike wrote this blog post, but I do not think, I know there was one in 2022 where they said something was unconstitutional under the major questions doctrine, which is different than this. They did not say it was unconstitutional because it was unconstitutionally delegated. That is a serious, serious problem. And Aaron Gordon, in his awesome paper, Non-Delegation, points out how bad the results have been, using some numbers to explain how it's all played out. Of course, he starts out noting that the first operative sentence of the Constitution provides, just like we mentioned at the beginning of this episode, that all legislative powers herein granted shall be vested in a Congress of the United States. However, today, he writes, the foremost source of rules governing private conduct at the federal level is not Congress, but rather administrative agencies. That's the executive branch. So the executive branch is writing rules that have the force of law, and Congress is just writing some open-ended stuff saying, well, the executive branch will figure it out and write the law. And that's how it's played out. And here's some numbers from Aaron.
And what do you think is going on today with Trump and all that? It's not a constitutional issue that they're arguing. It's administrative. Okay? That Congress washed their hands of, gave the president the kingship, and the judges are thinking they're kings. So we got two kings fighting it out now. And then we got the Queen, Congress, and the Senate is kind of putting their little 2 cents in there. But they're the ones that washed their hands in the first damn place. So let's proceed forward.
Gordon's paper. Between 1976 and 2015, I guess what's that, 40 years about? I don't know, I went to government-run school, so I'm struggling with math. The number of pages of statutory law enacted annually grew from just over 4,000 to about 6,200. So pages of statutes passed by Congress went up about, what is that, 50%? I don't know, again, my math is terrible. 4,000 to 6,200. While pages of administrative regulation, that's the executive branch, soared, it almost doubled from 12,600 to nearly 24,700. The U.S. Code, he writes, currently stands at about 22 million words, while the Code of Federal Regulations is almost 5x, 103 million. So we can see that just over that 40-year period, of course.
And sit and think about that. Every single day, a judge is breaking the law. Every single day, a president is breaking the law. Every single day, Congress is breaking the law. Every single day, the people is breaking the law. Every single day, the persons are breaking the law. Every single day, everybody is breaking some form of what they call law. That is over-regulated. And that is a loss of freedom. And I said it once and I'll say it again. The 13th Amendment does not exist because we are administrative slaves.
First opened up by the Constitution-hating Supreme Court back in the New Deal. That hasn't changed much these days. But it's really created a